When I told him about the court order, he did respond, obviously upset. He was cussing me out in a text message saying that he was not going to pay that and we couldn't make him pay that.
Will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Judge.
Thank you. Okay, we've got a not ready from Miss Swallow, and for court rules on that, I'm going to put a few things on the record. Mr. Miller was served February 22nd, 2024 by personal service. Then Miss Thompson, you may call your first witness.
Your Honor, before I call my first witness, may I tender the exhibits?
Absolutely.
Petitioner's exhibit number 1 is the citation of service for the mother. Petitioner's exhibit number 2 is citation of service for the father. And petitioner's exhibit number 3 is court of continuing jurisdiction letter. Petitioner's exhibit number 4 is the adjudication of parentage. Petitioner's exhibit number 5 is the mediation settlement agreement. Petitioner's exhibit number 6 is the mother's affidavit of voluntary relinquishment. Petitioner's exhibit number 7 is the father plan of service. Petitioner's exhibit number 8 is the temporary order following full adversary hearing. Petitioner's exhibit number 9 is the status hearing order. Petitioner's exhibit number 10 is the review hearing order. Petitioner's exhibit number 11 is the initial permanency hearing order before final order. Petitioner's exhibit number 12 is the permanency hearing order before final order held on October 2nd, 2024. And petitioner's exhibit number 13 is permanency hearing order before final order held on December 4th, 2024. And Your Honor, the department asks that the foregoing exhibits be admitted into evidence.
I didn't hear any objection earlier. Now that she's named them all, nobody has any objection to renew, do they?
No objection.
No, Your Honor.
All right, then based on having heard no objections, the court will admit petitioners 1 through 13.
Your Honor, the department call its first witness, Ms. Sartucci.
All right, she's been sworn. You may proceed.
Ms. Sartucci, what is your role in this case?
I am the permanency specialist that is assigned to this case.
And when were you assigned this case?
February 16th of 2024.
And what were the reasons for the removal of the child, Jordan Miller?
There was a referral alleging physical abuse of the child on February 14th and a subsequent referral received on February 15th with the same allegations.
And where is Jordan currently placed?
He is in a licensed foster home.
And how is he doing in his current placement?
He's doing really well. He's been there since the removal occurred in 2024. He's very bonded to the foster parents.
And going back to the status hearing, did the father's family plan of service, did it become order of the court?
Yes.
And for the father's plan of service, what were the services ordered by the court for him to complete?
He had resource management and basic needs. He had substance abuse, parenting classes, domestic violence classes, and mental health classes as well, or individual counseling.
And did he complete any of the services or started any of the services?
He did complete a psychological evaluation. He did submit some random drug testing, and he did complete a initial psychological assessment with his therapist.
And for his random drug testing, what were the results?
He tested positive for marijuana and alcohol in April 25th. He refused the hair follicle on that same day, But then I was able to transport him for another hair follicle in Bernie on May 14th, and he tested positive for marijuana.
And what was recommended for after his psychological evaluation?
He was recommended psychoeducational classes, parenting classes, anger management classes, substance abuse, behavioral therapy, individual psychotherapy, random drug and alcohol testing.
Okay. And did he complete any of those classes?
No, ma'am.
Did you uh follow up with him as to why he didn't start any of his classes?
Majority of the time, he was non-responsive to me and the providers, which was a reason that he was dropped from most of the services, and some he was not reaching back out to get stuff rescheduled. Um, but majority was his non-responsiveness to the providers.
And did the court order the father to engage in anger management class with his therapist?
Um, they did court order for him to address anger management in his therapy with his individual counselor, but if he did not do that, then he was ordered to complete a separate anger management class.
And did he do that at all?
No, ma'am.
And how about visitations? Did he have did he have any visitations with Jordan?
He did have some some virtual visits. He did have an in-person visit on April 25th. And then he had another one on May 15th. And then his visits were suspended at the next court hearing on July 17th due to him not responding to our MCA that was requiring 24-hour confirmation for these visits.
And how were the visits on April 25th and May 15th?
On April 25th, it was a very short visit. Jordan was very uncomfortable. He was inconsolable. So that visit ended within about 10 minutes, probably less. And the visit on May 16th went a little bit better, but his mom was in attendance to that visit, so that helped.
And at the time, was the father in another state at the time? What state was he residing?
He's been back and forth throughout this case in Virginia and in Texas. So I believe from around March to April, he was in Virginia and then returned to Texas on April 19th. And then he was non-responsive June, July, which I believe he initially stated he was going to boot camp, but did not disclose where. And then I heard back from him in November of 2024 that he was residing in Virginia.
Did he pay in-kind child support for the child?
No, ma'am.
So did he pay the increased amount that was ordered for the court, the amount of $231?
No.
And did you follow up with him as to why he didn't make any payments per court order?
When I told him about the court order, he did respond, obviously upset. He was cussing me out in a text message saying that he was not going to pay that and we couldn't make him pay that.
When was the last time you had any contact with the father?
I believe it was right before Christmas on December 23rd.
And what was the nature of your interaction with him?
I was trying to ask him about status or updates on his services. But then he became aggressive towards me, sent me a voice memo.
Judge,
And
I'm going to object to relevance.
Sustained.
Mr. Tucci, did you schedule an Ozark for the father?
Yes, he was scheduled for an OSAR for June 10th.
And did he complete the Ozark?
No, ma'am.
Um, did he have a chance to reschedule one?
Yes, I did provide him with the information to reach back out to the provider to get rescheduled.
And did he reschedule his appointment?
No, ma'am.
And what was the reason why he missed his Ozark appointment?
Initially, he said because he was at work and his call only received, or his phone only received phone calls under Wi-Fi.
Do you think it's in Jordan's best interest for the termination for the father's rights to be terminated?
Yes, I do.
And do you also think that the relinquishment of the mom is in the best interest of Jordan as well?
Yes, I do.
And why?
Jordan has had little to no interaction with both parents throughout this case. And the interactions that he did have were either over a screen for virtual visits where there's no bond being created between them. And there has not been sufficient care for this child from his parents. And there has been no acknowledgement or accountability for how Jordan sustained the injuries when this case came in. And in his current foster home, his foster parents are meeting all of his needs and more, and he is visibly bonded to his caregivers.
I pass the witness, Your Honor.
All right, Ms. Savage.
The department is willing to accept the mother's relinquishment and terminate solely on that relinquishment.
Yes, ma'am.
And in your conversations with Ms. Jenkins, do you believe she understood what the relinquishment meant and her having her rights terminated?
Yes, I do.
And she did have the opportunity to discuss the relinquishment with her attorney prior to tendering that relinquishment. Is that correct?
Yes.
And in your discussions with Miss Jenkins, did she believe this placement for Jordan was in his best interest?
Yes.
And did she support this placement adopting him?
Yes, she did.
I'll pass the witness, Your Honor.
I'm making sure I'm staying in the right order. Ms. Swallow.
Thank you. Mr. Tucci, based off of your testimony, is the department requesting that if the court's inclined to terminate my client's parental rights, that the court proceed on O grounds only for failure to complete his court-ordered services?
Yes, ma'am.
And in regards to communication with Mr. Miller, at some point, I began to communicate with Mr. Miller for you, correct?
Correct.
Okay, so while you were unable, you did not continue to communicate with him prior to Christmas 2024, you still communicated with him through me.
I did.
Okay. That's all I have. I pass the witness.
Mr. Saldivar.
Do you believe that the relinquishment from the mom is the best interest of the child?
Yes, I do.
And essentially, the father did no services and visited one time, and it was not a very good visit. Is that correct?
He visited 2 times in person and several times virtually.
Okay. And do you believe that was enough for him to create a bond to this child?
No, I do not.
Okay. And do you believe it's in the best interest of the child to stay in the current placement and be adopted by the current placement?
Yes, I do.
Pass the witness, Judge.
All right. Ms. Thompson, next witness.
Your Honor, Ms. Sartucci is the department's only witness.
Okay. Ms. Swallow, any witnesses?
No,
Ms.
Judge.
Savage, excuse
Oh,
me.
sorry.
No, it's
No,
okay.
Your Honor, no witnesses.
Ms. Swallow,
No witnesses, Judge.
Mr. Saldivar.
Mr. Judge.
Sorry, what'd you
Oh.
say?
No witnesses, Judge.
Okay, then with that, I'll just hear closing from anybody who, let's just start with the department. We'll just go through the closings in order.
Your Honor, it's in the best interest of Jordan Miller for the parental rights to be terminated. On ground K, the mother tendered a voluntary relinquishment. For the father, he has not, as you have heard through testimony throughout this trial, he has not made any reasonable efforts to try to have any type of unification with his child, try to achieve that. He did not make any effort to try to do what was ordered by the court to ensure that he's on the right track throughout the course of this case. He has not made any attempt whatsoever to fight for his child, to prevent any type of to prevent his child to not be reunited with him. He has not shown, in my opinion, the court or anyone else that he truly cared. And for that reason, Your Honor, based on the old ground that he failed to make any attempt to complete his services that were ordered by the court, it's in the best interest of the child for Jordan to be adopted by the foster parents and for the rights to be terminated.
Thank you, Ms. Thompson. Ms. Savage?
Your Honor, I would ask the court to accept our mediated settlement agreement, accept the mother's relinquishment, and terminate her rights solely on that relinquishment. The mother's desire was for the child to remain in this placement and be adopted by this placement. So we'd be asking the court to approve those agreements that the parties have made.
Thank you. Ms. Swallow?
Thank you, Judge. I would request that if the court's inclined to terminate my client's rights, that it proceed on O grounds only. And as far as Mr. Miller not caring for Jordan, I will say that he cared deeply for his son. He knew he was in a position not to be able to take him in and take care of him. But he did care deeply for his son, and he's been trying to accomplish signing a relinquishment. So he does care. I just want to make sure that's understood. You know, I know some very horrible things happened to this baby. We just don't know who did it. And with that being said, I know my client cares very deeply for Jordan and appreciated anytime he got photos. I mean, he would respond immediately when he could see his son. So I think there's a disconnect there on the understanding of Mr. Miller. My hope is that, you know, he does well with his life and things improve for him, but I just want it known that he did care deeply for his son.
Thank you, Ms. Swallow. Mr. Saldivar?
Judge, I believe this is in the child's best interest. I believe this was a D&E case all day long. I believe that dad's getting a gift here today by just terminating just on O grounds. I don't buy that he cared about this child. That multiple times during this case, he said he believed he wasn't the father. He didn't show any remorse for this child, any care for this child, support for this child, Judge. So I'm asking you to terminate his parental rights and accept mother's voluntary relinquishment, Judge.
Thank you, Mr. Saldivar. CASA?
Sue Jule here. I agree that the father's rights should be terminated as well as the mother's. The child's in a good placement, bonded with its foster family, and is thriving at this point. So it would be in his best interest to remain and be adopted by placement.
Okay, thank you, Ms. Jule. Anything else from you, Ms. Thompson?
No, Your Honor.
Okay. And for the purposes of the final trial, the court finds that all parties have waived any objections to the court hearing this remotely, and the parties have presented the court with a mediated settlement agreement that the court has accepted, found in the best interest of the child. This is the court of continuing exclusive jurisdiction. No evidence of any other court having exclusive jurisdiction has been presented today, and the court finds that it has jurisdiction over the parties in the subject matter. The court finds that the department has proved by clear and convincing evidence that the mother has, before or after the suit was filed, executed a voluntary affidavit of relinquishment pursuant to Chapter 161.001 B1K, and it is in the best interest of the child to terminate her parental rights solely on that ground. And the court finds that the department is proved by clear and convincing evidence pursuant to Chapter 161.001 B1O that the father in this case has failed to comply with the provisions of a court order that specifically established the actions necessary for the parent to obtain the return of the child who's been in the permanent or temporary managing conservatorship of the Department of Family Protective Services for not less than 9 months as a result of the child's removal from the parent under Chapter 262 for the abuse or neglect of the child. Court finds that his termination is also in the best interest of the child and will name the Department of Family Protective Services / belong as the permanent managing conservator of the child of this suit, Jordan Miller. Court finds that it's in the best interest of the child to maintain the appointment of Hill Country CASA as guardian ad litem and Richard Saldivar as the child's attorney ad litem. Court will dismiss Ms. Savage and Ms. Swallow and find that they have satisfactorily performed their duties in this case. Court finds that the child is currently in a placement that's safe and appropriate, meeting the needs of the child and in the child's best interest to continue. Court finds that the permanency goal is adoption and that permanency goal is in the best interest of the child. The court will hold a permanency review after final order on May 7th, 2025 at 2:30 p.m. May 7th, 2025 at 2:30 p.m. Ms. Thompson, is there anything I failed to address?
No, Your Honor.
Okay.
Judge,
Thank
was that
you all. Go ahead.
the next hearing was at 2:30? Sorry, I
Correct.
missed the. Okay, thank you.
You're welcome. Okay. Thank you all for your time and your service.